Evening, council and members of the community staff. My name is Tristan. I'm a third-generation Hayden resident, raising the fourth. I'm against some of the proposed changes in Section 4. I appreciate the assurances that that these sorts of things won't be weaponized, but the fact is that within a span of a few years, everybody here could be different, and those assurances don't really go very far. What does go far is what's written in black and white. Idaho law, I did some research, has some important clarifiers about public nuisance. And the public nuisance, what the definition of public nuisance in this document is not the same as Idaho's definition. Idaho just calls it a general nuisance. A public nuisance adds additional components related to the broad impact to others. This statute doesn't say anything about it. It doesn't say one neighbor, 5 neighbors, 10 neighbors. Idaho Code 52102 defines a public nuisance as one that affects at the same time an entire community or neighborhood or any considerable number of persons. And this seems to omit that important clarifier. It has only a general nuisance, so what is being called public nuisance is not the same as Idaho's definition of public nuisance in its entirety. It's incomplete and unnecessary, and I don't know if it would be enforceable if it were challenged because of those discrepancies. The broad impact language is important. It's not just technical, but it's distinct in Idaho's law. Without that clarity, the proposed language conflates those individual types, which also include private and moral, lumping them all together. References are 52107 for private and 52103 through 106 for moral. All of those are distinct in Idaho codes and have distinct elements. So cities don't typically become involved, especially the size of Hayden, in civil, small, private nuisance matters. Those are typically handled at tort, and they're typically handled either I'm reaching over my fence, or they're handled through civil sorts of things. And so this ordinance makes no differentiation between, I've got one neighbor coming after me trying to weaponize this, or I've got 5, or I've got 10, or I've got 1,000. And there are differences in scope, right? It's also important that clear language be on the books because it protects we property owners from being subjected to government enforcement over those purely private disputes or minor conditions that don't impact the community at scale, which is what I hear being said. Like, we don't intend for these things to happen, but if they're in black and white, they could be misused if it's not clear. The other pieces in there, it talks about the language which is offensive, which is subjective, and interfere with the comfortable enjoyment of life, which is also rather subjective. So I also echo that question, like, who decides? Like, as a resident, I might be served with something, but I want to know, who was it that was spying on my property and who's offended and who's not very comfortable. And I'm sorry, but I have probably close to 40 different properties that border my property. And I don't want to take a coin flip of 1 in 40 that I might potentially, I want to be a good neighbor, but I might offend or make someone uncomfortable in any number of ways that are enumerated in the statute. And I disagree also with the possibility of jail time. I think that's a significant overreach. Under the current code, repeated infractions can be seen as a misdemeanor, which already can have jail time. The judge already has the latitude to go there if they need to. So no threat for jail time is necessary. And it seems kind of like the poor person put in debtor's prison where, if I'm in prison for 6 months, I can't rectify the issue very well. So I don't think that needs to be in there. Councilmember Erickson, to your question, I did a little bit of research. There's not a lot out there about what cities choose to do in terms of enforcement, but the number that I got for large cities, and I can give you the reference, I just need to dig it back out, was 26% of large cities had any sort of jail time associated with nuisance code enforcement. Those are large cities, probably more liberal leaning. In my estimation, there's no solid numbers for smaller cities, but I would guess the number is less than that 26% that you would see in larger cities. So, as my time is probably running out, I suggest that treating overgrown weeds or accumulated junk or similar property conditions not be jailable offenses. Those are ordinary maintenance disputes, and there's a civil way for those to be taken care of. And sending somebody to jail consumes limited law enforcement jail resources that should be reserved for actual public safety threats. So I encourage you to not adopt this language as written and to revise it to conform better to Idaho codes and have greater clarity.